Okay, and I see John has joined us. That's good. This is a meeting of the pretrial processes work group, and it's been a while since I chaired one of these meetings. I'm Judge Deborah Garrett, and present at the meeting are Stephen Gockley, David Graham, Andrew Peterson, Judge David Freeman, Court Administrator Dave Reynolds, Jill Nixon is with us, and Carol Donovan is with us as well. And John Kraus, are you with us too? John is trying to connect, and we're hoping he'll succeed. He's been having some connection issues. Okay. Well, as you know, excuse me, there's someone at my office door. I'll be right back. How nice of you. Thank you, Kelly. That's really nice. I will see you later. Okay, thank you. You know, I really, so far, recommend the last week of employment. People send you nice emails and they stop by your office with presents, and it's really quite a nice thing. Okay, excuse me for the interruption. We have I'm sorry, I'm not as organized as I could be or should be. So Stephen, I'm going to be looking to you for pulling us back on track when we need to do that. But we're following up on our discussions in our 2 discussion meetings in December. The purpose of our group is to make recommendations to the judges through Judge Freeman about pretrial processes generally. And we've been taking a fresh look at pretrial processes with our reassessment of the Arnold Foundation tool. And I think it's been our consensus in those meetings that we're aware of race-based criticism of the tool. We're aware that there is criticism that pretrial assessment tools can have disparate impact on minority people, not so much in and of themselves. The tools it's not inherent in the tool, but it's because tools use criminal history, and that can have a disparate impact. If I'm, let me put it out there because I want to be sure I'm right. My sense at our previous discussions has been that we're wanting to proceed with implementing the risk assessment tool that we've geared up for and trained for, and that we'd like to do that pretty imminently so that we can start updating the data that we've already compiled to give to Dr. Peterson so that he can continue in his work of validating the tool and making sure that it has a fair impact on our population and that it does in fact reduce incarceration. First of all, did I read the consensus of the group correctly? And I note that Maya's not here. She may have a different view, but what do you all think?
I missed the last meeting. I'm sorry that I was actually on vacation, but the meeting we had before, I know there was some discussion about the fact we hadn't been utilizing the tool so far. Is number one, is time consuming and we're limited on resources. And secondly, having a risk level that we can't really respond to based on a risk assessment. My question was, how much sense did that make at this stage? If we have somebody who's high risk, yet we can't provide high risk monitoring, does that put us in a liability situation? Does it put us in a situation where that information is really not that meaningful to us because we can't respond in a manner that we need to?
Yeah, I understand. The COVID pandemic has done 2 things, it seems to me. First, it's raised the issue that Dave just described. We're not able to give high level pretrial services because they require personal contact that isn't permitted under current restrictions. And then the other question is the court has radically changed its pretrial release policies because of COVID, and a lot of defendants, and basically defendants who don't who aren't accused of a violent crime and for whom there's not a specific reason to suspect, or more than suspect, believe that there'll be harm resulting from their release, either to the community or to a specific person. Those people are being released. So the jail count is at a low that I guess I wouldn't say it's unprecedented, but it's not typical at all for recent years. And so where does that leave us with pretrial services? Now, there's a hard question.
You know, to kind of follow up on Dave's comments about high risk, I wonder if we could maybe adapt the high risk sort of criteria during COVID, like we have a lot of the other court rules that maybe people don't have to come in, but they have to be in contact once a week or twice a week. Because I think that's the major difference. And Dave can correct me if I'm wrong, between.
And I think we do have a higher reporting requirement for them currently. It's not in person, but it is, by phone and stuff. And I think, one of the things that stand out to me is, what's the outcome we're looking for from this with pretrial? Are we looking at people not committing new offenses when they're on pretrial? I don't think we're in a position to do that, regardless of a risk assessment or not. So what is it we're gauging as success for this? Is it people coming to court, people being in compliance with release conditions, those sorts of things? I don't think, even if we had more staffing in pretrial, I don't think we're in a situation where we're going to keep those people from committing new offenses. And I know that's a concern with this group, and it should be a concern with the numbers are fairly high with people coming back through on there. One of the things that really stood out to me, having gone through a negligent supervision lawsuit about 20 years ago with the county, one thing that really stood out to me is, the burden of you knew or should have known. One of the two. And I think if we have a validated assessment that we're using that says this person's high risk and we can't treat them any differently, I think that puts us in a situation where we knew there's something differently should have happened with this person and we didn't.
My thought on this was, I think, as in almost all areas, COVID restrictions and guidelines supersede anything else. So it struck me from the earlier conversations that we did have consensus on recommending adoption of the PSA. When and how we implement that would seem to me to be an open question, and we might recommend that it actually be implemented once COVID restrictions are lifted and we can return to a more normal regime of pretrial release decisions and oversight. I'm still troubled by the resource question, because not only are we not prepared to monitor high risk, if I understood the conversation in the last meeting, we didn't have anything distinctive for moderate risk either. That everybody was getting the same minimal low risk level of supervision. And Dave, correct me if I misunderstood that.
That's correct. Moderate and low are being treated pretty much the same. They're receiving phone calls. They got minimal check-in requirements, those sorts of things.
So I don't know what we do with that. And what the conversation last time seemed to suggest that prospects for a capacity to do more oversight was not very promising in the near future.
Well, I think if we take away from that, time allowable for monitoring people versus we're having to administer the risk assessment as well. What do we want to put our resources into? People administering that risk assessment takes, several hours a day, or, being able to receive phone calls or track people down or those sorts of things. So where do you put your limited resources? And John can correct me on this, but it takes, several hours a day to hand calculate the risk assessment.
Yeah, that's correct. It's all manually put in, since the systems don't share from the state databases to our program that we use, as well as highs do report in, though. They are required to make contact with us weekly, and they still get a violation if they don't make a certain amount of contact within 30 days or so. They do. So they're still held to a higher, they just don't report in person to the office with the COVID policy.
And I think we did make a change recently where people who haven't been in contact with more than 30 days or notices going to the court. Is that correct, John?
Yes, that's correct. For both low and medium, we've got that. So we try to track them down. If not, then we let the court know. It's not a violation hearing. It's just simply notification to the court. So.
And maybe I can ask the judges, Judge Freeman and Judge Garrett, have you seen any of those notifications or on some of the status calendars, or where we're calling cases, or are they just kind of buried in Odyssey? Or
I haven't, but I haven't. I think I did status. The last I did the criminal rotation was the week of the last meeting we had where we discussed it. So those notices would not have been coming in at that point. I don't know, Judge Freeman. I don't remember when you last did the calendars. Have you seen those notifications?
I seem to remember when I have Odyssey open and I'm scanning for things that occasionally I will pick up on a notification. I will say that was a shift from earlier this summer where we were seeing them ex parte as it wasn't necessarily a request for a review. It was a court action. Basically, do you want to review this? If so, then the judge would make the decision to have it noted. I have not seen those in a couple of months. So,
and those are for the high risk cases judged.
Yeah.
Yeah.
Exactly.
And notice is simply for the moderate to low to medium.
Right.
Really new. Yeah.
So they're not really, and I don't think the prosecutors are bringing them to my attention. So it's usually only when I'm scanning through Odyssey that I pick up on those being filed.
So we need to figure out what we want our pretrial services department to be doing, because it sounds like it takes basically, what would you estimate, Dave, a half person full-time equivalent to?
Well, I had reassigned Linda Telfer from the clerk's office to help gather information for pretrial, and using a person out of juvenile too, just to gather the information to pass on to John and Alan. So there's a fair amount of work that goes into gathering that information and passing it on, and they have to hand put the information in. So John's probably in a better position to answer than I am how many hours per defendant that takes, how much time per defendant.
Is there any hope of a better technology connection with the state information? Maybe this is a question for Dr. Peterson, to streamline that process.
Yeah, Carol, there's hope. There's always hope. But I don't know how strong the hope is right now. Currently the AOC supports the adult static risk assessment, which is the tool that was created back in 2012. That I think is still used a little bit in Whatcom County, at least in the district courts. And I've had talks, I've let the IT know that a lot of people are using the PSA, a lot of different counties are using it now, and that it would be really helpful, beneficial to them. It's a question of where that priority falls and their list of other things they're working on. So I keep pushing for it, but I don't know how to move it up that list right now, unfortunately.
When we're gathering state information through Azure, but we're also doing NCIC, out of state, which isn't, isn't local as well. So we're having to check against those. If there's no local criminal history, check NCIC and run that as well. So we're capturing nationwide too. So.
Is there a way to devolve the manual data entry from the level of John or his supervisee to a more clerical position and somehow cannibalize some of that resource?
The clerical positions are the ones gathering the information to pass on to John and Alan, and they're the ones who do the calculation because they're the ones who are trained in it, the risk assessment. So a lot of the legwork's being done by clerical staff as it is.
What is John doing then? He's running the software?
Yeah, he hand puts the information into the risk assessment tool that calculates it.
That's my question.
He and John are John and Alan are the two that went through the training with the Institute for that.
Is there a way to have the actual entry of the information? I guess you're saying it had to be someone who was trained on the software to enter the data into the software.
Which we had planned to do at some stage. We're in a hiring freeze and we don't have the ability to do that, nor can I pull away from, I'm short staffed in the clerk's office as well. I can't pull them away from any of their duties there in addition. So, if we, and that was our plan in the long run, to look at, once we had John and Alan on board, what resources we had available to hire support staff or increase time for support staff or hire an additional pretrial services officer at that stage. And of course, again, we're in a hiring freeze. So we're kind of really in a holding pattern until some things can change.
And prospects don't look very good. I mean, just given the fiscal situation of the county, the state. Oy.
Yet another layer of reason why we just may not be ready to implement the PSA.
I think if we're going to implement, we need to be able to respond, and I don't know that we're able to respond in a different way than we are now.
I'm sure this has already been discussed, and I'm new to the table here, but I mean, it just seems to me that a lot of the inputs are just going to be skewed right now with COVID, because it's not just the decisions that the judges are making at first appearance as far as what factors we're using to hold somebody. It's also the jail booking restrictions that are not typically in place. Right. So there's a whole nother level that is being filtered out from what we would see typically. So I guess my concern is just the measurement of success and how we're going to evaluate that if our inputs are being skewed due to COVID.
Yeah.
Drew, are you seeing in other jurisdictions ways around some of these resource limitations that we're discussing here?
It's a good question. I don't know. I mean, I think these are common concerns that I've heard, but I haven't talked to Yakima, for example, in a while. And they're the ones with the most experience at it. I know the last time I talked to them was, it's been a while, like I said, more than a year. And they were still doing everything manually as well. So, and that was, I was talking to them pre-COVID, so I don't know what they're doing now.
And we are working on a supervision module through juvenile court, which is tied to our Odyssey case management system in Superior Court, which we do hope in the long run we'll be able to extract information and pull into the risk assessment there that we'll be able to run to give us some additional resources on the PSA. However, we're in a holding pattern with AOC on that right now too. So had hoped a number of these things would be in place by now, and COVID just really turned everything upside down.
Sure did. Sure did. Well, then I guess the next question is, are we making the best use of our pretrial services unit resources? And if not, should we be, be doing something different with pretrial services until things get back to normal, I guess, for this unusual interim? I don't know. How does the workload look currently, John?
We've got 195 on supervision. That's all levels combined. And we're probably averaging several reports to the court a week, criminal history checks, getting update information for texts and those kind of things. We always are available to have people sent to us as an alternative to bail or with bail, or we're always there for the courts as an alternative if they want to impose something on the conditions of release. I would just say we're always an option there available for supervision at whatever level you deem necessary. I'm thinking of, with COVID restrictions, we still can monitor them via electronically. A lot of their activity, if they're on the high end, they are supposed to make contact. The low and medium do need to provide us with contact information for those court reminders. And now, since we instituted that other policy a couple of weeks ago that Dave had brought up, and we're going to start notifying the court if they haven't made appropriate contact with us, both low and medium, which is good to see overall compliance to their conditions of release. That's a great indicator. So does that help?
Yeah, it does. So
I'm not sure what else we could be doing at this stage, given the limitations.
And that's kind of the exact question I was going to ask John. Are there any things you feel resource-wise you're unable to do that you'd like to do, or any sort of things that you would like to shift things around, some duties you're doing that you maybe think aren't as helpful as other duties? I know you've been doing this kind of stuff for a while, so you're kind of the expert on it.
Well, novice expert, how's that? I would like to, at some point is when I talked to our trainer last year, and we have ongoing relationship, he had mentioned, to tweak our reporting policy. That'll be a point of conversation at some point too when COVID starts to release. But, the highs would look a little different, the mediums would look a little different, and the lows would look kind of the same. But he was just saying, his background, that would be one thing. I really wish our state system shared, more information. That would be a real tremendous help. I think between the both of us, both Al and I, we're maintaining, 195 is a good caseload number. We can still handle more. And resources at this point, if we can't have face-to-face contact, I think we really do. We have a text system, we have phone-in system, email, and it's all connected to the database that we have from our vendors. So that's very helpful.
the other thing is you don't have people going out of pretrial services because we're not doing trials. So people land in pretrial services and they're there pretty indefinitely.
Yeah.
And you're seeing the effects of that now. Those effects are probably going to continue for a while, I would think. Certainly.
Yeah. There's been people on since 2019, so.
Yeah. Yeah.
Can I ask a question?
You bet.
I'm thinking again about the small proportion of high risk cases. And I know in the courts of lesser jurisdiction where I work, there are some monitoring tools that we have had available that I think are not available in Superior Court, as far as some electronic monitoring, GPS monitoring, devices that monitor alcohol consumption. I know all of those options are also not without controversy, but I'm wondering if there is a time when we want to even have a discussion about whether any of those tools might be helpful as tools to have available in certain cases.
I can answer that a little bit. We have talked about drug alcohol monitoring. When, pre-COVID, we were working towards that. We probably use our drug court contact for like random drug, unless there's a treatment provider, but usually we probably use, random call-ins to drug court. Could either have them on a scheduled or random, or if the conditions of release have a specific condition on there for that, at a specific time, date, and, or one time or something. But that, I think that is great. And I think we can move towards that in the future, kind of when all this lifts.
And Dave Reynolds may correct me if I'm wrong. So the UA collectors through drug court, they work like for Superior Court. So there wouldn't be any issue with them doing extra work or anything like that.
Good, Dave.
Dave, your phone's muted.
Thank you. Yeah, we've used them in the past on pretrial services. So, and they're available, you know, on the weekends and stuff too, which, you know, our pretrial services isn't. But if we need somebody who needs extra monitoring, they can get a urinalysis, you know, Saturday or Sunday, who is a check-in. So,
and I think we can maybe tie it in. I know we do drug court. There's just a call-in line, you know, for the random UAs, and that's something that could be in the future. We could look at.
Sure.
You know, the pretrial services officers could just give them this number, like, hey, you need to call this recorded number, and if your color or name comes up, or however we do it, that'd be a good way to do it. But that's something, yeah, I think that'd be great to discuss in the future once we're up and running again.
And as
along with, I was just going to say, along with, we had our database can take on kiosk machines. If we place them in different places that's hard to get to, and you can instruct them through that. They come in and check in through that. They'll have some instructions on there, updated contact information, or those kind of things.
I was just going to say, perspective-wise, as far as the municipal courts go, it's, you know, it's a mixed bag there. With district court, it's all in-house as far as the GPS monitoring and things like that. When you go to the municipal courts, it's some, I think some are still using district court, but for the most part, they're contracting through Friendship Diversion Services for that type of monitoring.
And then do they pay privately for that, Dave?
Yeah.
Yeah.
Yeah, and that's, if it's pre-trial, it's paid by the municipality. If it's post-conviction, then it's usually the offender expense.
I'm pretty sure with district court, the monitoring is only Monday through, for the reporting that they get, it's only Monday through Friday. They are monitored over the weekend, but there's no probation staff. But then they receive the reports on Monday. So if something happens Friday, there's no notification to the court till the following Monday. So it's not necessarily real time.
You know, in what turned out to be the good old days, although we didn't recognize them as that at the time, when we went to the county council to get funding for our pretrial services department or unit, the council was more than willing to consider electronic home monitoring expenses, and you know, was looking forward to us coming back for a separate request. Remember, we didn't ask for any EHM money when we started out because we wanted to establish the department and then move ahead step by step. Now, I think that, you know, the council members are understandably going to be much more cautious about funding even things like EHM that they all agree is a good thing. So I think we're going to have difficulty stepping up our pretrial services levels because I think it's going to be really hard to get county-based funding for the indefinite future. You know, I feel like we've just incurred so much expense because of COVID on every level, you know, operationally, and, you know, we've had, well, you know, most of us work in the court system. We know that it's just been huge, the effect of COVID. And we haven't had the second wave yet, which is going to be, well, we hope it's going to be a second wave and not a third wave. But the second wave, when the cases start coming through the court and the court is just deluged with these criminal cases that have all been on hold for a while. So money's going to be tight, I think, for the foreseeable future. Which means we need to be just as creative as we can be in doing the pretrial services and hopefully taking up where we left off on the pretrial risk assessment, which is basically the same thing as starting it, because that's where we left off. Yeah.
I have no reason to doubt the probability, the low probability of near-term funding from the county council. On the other hand, I would strongly urge us to consider making the request anyway, because it's a need. It is what we need, and you know, what we can say we understand the constraints. We can expect amongst ourselves that the answer will be no, not now, but at least it will be on the table. It will be an articulated need that the council is made aware of.
That's true. I think that's a good point. Yeah.
I think it's important to point out, we just submitted a 2-year budget, and the county had us submit 2 budgets. One was status quo and one was with 9% reductions across the board on things. So they weren't willing to look at expanding anything at this stage. It's just realistic on that. Doesn't mean we can't, go back and ask for money at some other time, but that's the directive we were given at that time is, one, hold the line, and secondly, expect 9% cuts.
Is the 9% across the board for county government, Dave?
Yeah. The only exception for that was like drug court, which is funded at a 1/10 of 1%. I think they had a 7% reduction or something like that, but everybody else was across the board. All county departments were at the same.
I think that addresses my idea.
And if we looked at, Judge Garrett remembered this, and Judge Freeman, but we were looking at probably a reduction in Superior Court overall of about 8 or 9 positions if that was to happen. And we can determine where that happens within Superior Court, but that's a good chunk of staff.
We'd be looking at reducing from the current complement by 8 or 9 positions. Is that right?
Yes, with the exception of a couple positions which have already been frozen.
I don't see how we could continue if we lost 8 or 9 positions.
Well, that was the struggle we had is, where do you take them from and how do you maintain infrastructure to keep going on things? So, but, labor is the only areas we had to cut it from. There was really no other place.
Yeah.
I'll just say then the other thread that I hear running through a lot of this is a common one across jurisdictions. We're far from the only county dealing with criminal justice reform. We're not the only county implementing the PSA. And so I'm wondering if I should turn to the legislative session and the Superior Court Judges Association lobbyists might make a pitch for multiple jurisdictions, or we could talk to local legislators about targeted funding for some of these needs. And I'm not sure how we would prioritize them since there are many, but.
Andrew, I think I know the answer, but I'll ask the question anyway. For a while, there was just, sort of brief discussion or rumor or whatever that AOC might take a position before the legislature to the effect that pretrial services in Superior Court should be promoted by and funded by the legislature. Do you know anything about that?
I don't know anything about that. I can ask. I'll reach out to my boss and other people around and see what I can find out.
Yeah, thank you. I suspect, though, that if you don't know anything about it, it's because it's not a subject of frequent discussion.
I mean, it's possible. I don't often. I stick to numbers outside of without dollar signs in front of them usually. So. It's not, I'm not always in those discussions, so it's very possible that that's happening just outside my circle.
Okay. Well, where should we go from here?
I think if I could just maybe chime into that, I think the more practical thing is to continue putting our resources into monitoring individuals rather than doing the risk assessments. I think Dave Reynolds brought us some good reasons why we probably shouldn't do the risk assessments right now and just kind of wait out this COVID and kind of put the resources that John has in monitoring. I mean, that'd be my suggestion. I'm not sure if someone else has another suggestion or different ideas or something like that.
I think that makes sense. Yeah, especially the reason that the judges are favoring release from jail in so many cases, it's because that's the directive of the Supreme Court. It's not like all the judges suddenly change their minds about pretrial release conditions, but the instructions have been do everything you can to not be incarcerating people. And as Dave Graham well knows, you know, when we issue a bench warrant for somebody that just fails to appear, does not show up for their hearings, even when we get to the point where we issue a bench warrant, which is usually on the third hearing, used to be the first hearing when somebody didn't show up. Now we give them another chance and then probably another chance. And then when we issue a bench warrant, it's a book and release bench warrant, which tells the jail to, the sheriff's deputies pick the person up on the warrant and bring them to the jail, and they get booked at the jail and given a court date and released, because that's what a book and release is. So that's really different from, quote, normal operations. And I suspect that there's no going back, you know, I mean, there's no going back all the way, I don't think, because now we've seen this system work. And by work, I mean operate. Whether it's working well or not working well is, you know, as they say, the jury's out. We need more information. But it's hard to see the courts going back to the frequency with which pretrial conditions have, other than pretrial services, have been imposed in the past, I think. I'm entitled to have an opinion because I'm not the one who's going to be making these decisions. But, you know, we've lived through an extraordinary year, and it's going to have some lasting changes. And I suspect that might be one of them. Judge Freeman, you don't have to answer. You have the right to be silent.
and if I can answer, I hope it's not. I hope we can go back to normal, because we're really getting swamped with new cases, and even the book and release people aren't showing up again, and we're put in this tough position about, okay, what do? Do we issue another warrant? Do we continue another week or two? And it's burying our calendars. I mean, I'll be doing a calendar tomorrow, which I've shuddered to see how many cases are going to be on there.
Those Wednesday calendars are terrible now. Yeah. And it's because, you know, I mean, the average case used to have, if the average case used to have 8 pretrial hearings before it actually resolved, either through trial or plea, now it has, you know, 15 or 20. So those Wednesday calendars, they take practically the whole day, and very little gets accomplished, other than we're seeing that, yes, Mr. So-and-so is still on our rolls, and we've heard from him recently or we haven't. And, you know, we hope for the best. So the changes resulting from COVID have been far reaching, for sure. So I guess really what that means is our discussions about racial impacts aren't especially time pertinent right now if we're not going to be using the risk assessment for the foreseeable future. And I don't know, Carol and Stephen and I have talked about rekindling our discussions with some of the minority and advocacy groups that we met with, yikes, a year and a half ago, about some of these issues, and getting some input from them and structuring the discussion, we hope, in a way that would give us more valuable input. But I don't know where we are on that in terms of whether we should be doing that at this point, or whether we should be holding off.
I guess I would say we should hold off, because we're not really doing the assessments. I think right now the judges have the discretion, not using a tool to put someone on pretrial services. So it's sort of the way we were doing things before. And I think as a group, we sort of reached a consensus that we were going to, time came, proceed with the pretrial assessments, but keep a close monitoring if we are showing this racial bias that, I don't want to say the statistics don't back up, but that is perceived in the community when we start going. So we'll be able to show like, look, it's, you know, or if we see something, you know, but I would say now.
So that keeps us in the pre-risk assessment phase of Dr. Peterson's review of things. You know, the numbers that he gets from current numbers are the numbers that would be the basis for comparison later. Unless there's no basis for comparison because circumstances are just different. Well,
that's an interesting question because excuse me, sorry.
No, go ahead.
I mean, we're in the midst of a grand experiment, whether we want to be or not. And so that does kind of raise the question of, are there things that we haven't thought about measuring or tracking in some ways that would help us to learn more from the dramatic changes that have been forced on the system at this point? And I guess that would be my biggest interest in thinking now about talking with the broadest people with the broadest possible range of perspectives would be more on those bigger questions than on the specific issue of the risk assessment tool. Are there voices or plans or questions or things to be aware of at this point where everything has been changed and mixed up and doors have been closed and opened, and we know we'll get back to something, but it'll be different from anything that we have seen in the past. And so we're in such a state of flux. Is that a place for a broader discussion?
That's true. That's true. That might be the opportunity at this point. I mean, it might be a good opportunity also to engage in a dialogue and establish those relationships with some of the people and groups that are advocating for racial justice, so that we can get their input on an ongoing basis. Maybe we could even put somebody from one of the advocacy groups into the task force, into this group, or into Legal and Justice. I know that's something Stephen would welcome. I don't have any suggestions as to who necessarily, but to continue discussions with people who are interested in those issues. I'm sort of thinking out loud here. Might be a good thing because we could strengthen relationships within the community.
I think there's value in looking at it that way. Whether it was a year and a half or 2 years ago when we met with people, I think the message we got was uniformly, don't do this. And I think for all practical purposes, we've decided to do this, even if we're not going to do it in the timeline that we thought we were. So initially, our thought was to re-engage in that conversation to sort of explain why we have chosen this path and what steps we might add to the path to ameliorate some of their concerns and start an ongoing conversation, which presumes establishing some working channels of communication. So I think we could do that constructively now, or there's no reason why we couldn't start that now and add the layer of focus that Carol suggested. Because I frankly, amongst this group, I don't see us going back on the decision to adopt a risk assessment instrument and have it be the PSA. It's a matter of timing and resources, it seems. So rather than staying dark for another year or so from that earlier conversation, it seems respectful and potentially useful to start talking in a broader context sooner rather than later.
And also to talk in a better context. I don't, my memory isn't consistent with what you said, Stephen, about it being pretty universal that people opposed this risk assessment tool. I think a lot of the people that we talked with said different versions of, I don't know enough about it to know. So I can't tell you, yes, go ahead with this. And, you know, we talked later and we thought, well, yeah, I mean, these people aren't involved in the criminal justice system. They may have citizens' concerns about the criminal justice system, but they don't know, you know, precisely what the process is and what the law says about, you know, when people are to be released and when not. And asking them about a risk assessment tool, the information they give isn't very helpful unless they've been better educated about the process and how a tool fits into that process than the people that we spoke with were. And I'm not laying out fault, but if I was, I'd put the fault on us because, you know, they're not legal specialists. They're doing their thing, and it's not law. And so, you know, I guess what I'm saying is there's a fair amount of discussion that has to happen before you even get to the question, because you want people to be able to give educated answers. And to do that, they have to have a better sense of how a risk assessment tool is used and how it fits into pretrial processes than people are going to have unless we educate them.
I think that's a fuller, more insightful, and shall I say, judicious summary of that conversation than I gave. The people who did voice an opinion about it, I think, were against it. But I agree with you, Judge Garrett, that there was a large portion of that around that table who did say that they didn't think they were able really to give meaningful input into the question.
Yeah.
So that would be an additional value to continuing a conversation, resuming a conversation.
So that means reaching out to the advocacy groups and perhaps to individuals who are active in the community of people who advocate for racial equity in Whatcom County. And we have a letter that I think I tried to fine tune the letter and get it into final form, Carol and Stephen, before today's meeting, and I just didn't get there. I've really been in overdrive these last couple of weeks, but we've got the letter, and we need to figure out who to send it to and when to set up a meeting to at least begin the discussion.
For the sake of the rest of the group, I think what the three of us have talked about is identifying some key people who can sort of be distributors into their own networks of interested community members and activists, because the response rate to our invitation long ago was not what we had hoped for. So we're trying to identify people who have those networks and extend both some information and an invitation to continue dialogue through those people. The contacts I've made tend to show a lot of people identifying similar key people for those networks. And also to state that in community groups, there are really two groups. One group is interested in problem solving, definitely with a point of view attached to it. The others are more, shall we say, revolutionary in their perspective and are less interested in solving practical problems and more interested in making broad and deep systemic change, which would be unrecognizable to those of us in the legal profession. So what sort of mix we want to shoot for in that conversation is a little bit of an open question, but
well, you know, the big picture people, you need to have some of them around to keep your eye on the ball. And yet, you know, as we've said in discussion, the question is for the judge that's sitting there on the bench looking at this guy and thinking, do I release him or do I put him in jail? What kind of help can we give there? And you know, so I guess a mix is the answer.
I think that whole question highlights what I've taken out of the Pretrial Justice Institute statement and the open letter from the data scientists and Dr. Peterson's own response is this isn't a single point. A pretrial risk assessment instrument is not a single point for addressing or not addressing racial bias in the criminal legal system, that it needs to be seen in the context of other measures that are taken to reduce built-in bias. And so if we as a group start thinking in those broader terms and making recommendations about other steps that we could take along with the pretrial risk assessment, I think that's a message that goes down more easily in the community. Mm-hmm. and frankly is a better, more holistic approach to incarceration prevention and reduction.
And maybe puts us in a position, our group educates us to the point that we can make some recommendations about other measures that could be taken that the judges will find helpful. Yeah. So where should we go from here?
Yes, my first question is to the other members of the group. If the three of us reached out in the way we've described and got some response of interest in a community meeting conversation, would that be something the rest of you would be willing to participate in, or would you want to delegate that to some subgroup of our work group here? Or
well, I would certainly be open to it. I don't know who we reached out, because I'm really involved here. I don't know who we reached out to during the initial conversation. But yeah, I would certainly be open to that.
Yeah, me as well.
Good, good. Well,
I do have some pretty strong connections with the Human Rights Task Force, some folks on that, with that group. I don't know if they were part of the conversation the first time around or not.
They were a key part of that, I think. You said you have relations with them?
A few people in that group, yeah. Specifically Bonnie Johnson, but.
Yeah. Damani didn't come, Michael Barris, a couple of other people from, I think they had 3 people there.
Yeah. One thing that you or I could do, Dave Freeman, is talk with Damani about suggestions for people and groups. Damani gets called on for this stuff all the time, and I sort of hate to, you know, call him up with yet another question, but he really does, you know, have a much better sense of the community than we do in that regard.
He's also very much a big picture type of person as well. And so if we're trying to get the big picture aspects of it, as well as the other, then I think he would be a very good voice in that.
All right. Well, that's.
I'm more than happy. Yeah, I think I owe him a phone call anyway, so I'm more than happy to have that conversation.
Okay, good. Good, yeah. Did we ever figure out, Jill, what you have in the way of records from our previous meetings and discussions?
What do you mean records?
What do I mean by records?
Yeah.
Like what groups we reached out to and the names and perhaps contact information of the people that we contacted then?
You know, those invitations and connections did not flow through me. I think it came from, Stephen, did it come from you? Were you a part of that?
I think they came, the invitations went out probably through Carol and me primarily. But Jill, might you have a record of those who actually participated in the meeting?
That's what I'm just wondering. I can look and see if there was any kind of a sign-up sheet submitted at the time or provided at the time. I don't do written summaries for these work groups, but I may have kept notes, and we always of course have the audio, so I can take a listen to that and see if I'm sure there would have been at the beginning of the meeting an introductory phase. So I'll do a little research and see if I can come up with some names and contacts for you.
No one would object. I would suggest that Judge Garrett, Judge Freeman, Carol, and I proceed to develop a contact list to which we would send the final version of Judge Garrett's letter and maybe one or two enclosures for background information, inviting people to participate in this kind of conversation. And Jill, you can feed information into the development of that contact list to the extent you can find any.
Yeah, sure. And just as a reminder, the county administration is in the process of putting together its Racial Equity Commission. And one of the discussions I want to have with the Task Force Steering Committee is putting together a list of questions about which the task force can engage with the commission once that is formed and gets up and going. And so this might also be another avenue. I don't know what their timeline is or where they're at in creating that commission, but that's another resource I think to keep in mind for you guys as well.
Yeah, absolutely. Yeah.
Two of the people who have been mentioned frequently as distributors for our purposes, Xiling Zhao and Christina Michelle, are right in the thick of the formation of the Racial Equity Commission. So there's all sorts of overlap here in these conversations, which there should be, of course.
Well, Andrew, were you going to say something?
I was just going to say, yeah, I think Jamie Hawk from the ACLU was at the last meeting as well. And I know her from work on the statewide committee. So if you need a contact or anything, I'm happy to.
Okay.
Yeah,
yes.
I know Jamie as well.
Oh,
she was there and would be someone we'd want to contact again.
Okay, great.
And if we can figure out who Jasmine is, there's a woman named Jasmine who was there as a representative of Black Lives Matter, and she was, boy, I'd really like to have her involved. She was just very articulate and not jumping to conclusions. She just seemed like a good mind to me, and it'd be not. But all I know is her name's Jasmine. I think it might be spelled Jazzmyn, but it might be spelled like the flower. I'm not sure, and I never did get her last name. I'm in the process of going through my voluminous notes so that I can turn them all over to Judge Freeman, lucky guy. And I haven't come across my notes from that meeting yet, but I haven't been through all my notes, so there's hope.
I think Carol tracked her down, Judge Garrett. I think we have an email address for her.
Oh, good. Okay. And speaking of email addresses, Jill has my email address. Well, when Jill sends out mailings, you'll see that she'll send them to my personal email address starting next week. So that's where I can be contacted.
The other jurisdictions that have adopted the PSA, have any of the minority bar associations been involved in that discussion in the other jurisdictions?
Not that I'm aware of. We're looking primarily at Yakima. Spokane adopted it also, and I'm talking about counties. Spokane County adopted it, but then a bunch of things went wrong in Spokane that didn't have really to do with the assessment tool, but did have to do with local politics and conflicts. I've just told you everything I know, but that's what I understand. In Yakima, they did adopt the pretrial risk assessment, I think with more consensus in the community. And our information is dated and pre-COVID, but at that point, they were doing pretty well, and they had pretty much ended the racial and ethnic disparity that was showing in their numbers before they started using the PSA. Am I remembering that correctly, Andrew?
Yeah, so they just did a quick kind of preliminary study, but their numbers, you're right, your responses are correct.
Yeah, okay, good.
Would it be relevant in the medium-term picture for us if Andrew recontacted Yakima and tried to get an update on how they're dealing with COVID factors and how the PSA is looking in that context?
And how they're, I mean, they're subject to the same Supreme Court directives about releasing a lot of people that they wouldn't otherwise be releasing without conditions. So yeah, that would be helpful. Could you do that, Andrew?
Sure, yeah, absolutely. I'll reach out and get an update. And I'll also, you know, I'm not sure, there may be more questions than I have, or that, you know, questions may come to you that may not come to me. So I'll get kind of some quick answers and then see if they're willing to talk to you directly as well. That may be more useful.
Great, that'd be good.
Great.
Andrew, are there other jurisdictions that you think might be worth contacting and getting status reports on? PSA jurisdictions?
Yeah, let me talk to, so Thurston and Pierce are still in the process of implementing, so they haven't, I think it's a little too early to talk to them yet, but Clark was using it as well, but I'm not sure, again, I don't know at what stage, so I'll reach out to them as well.
Good. And you think you can report on that at our next meeting then?
Yeah, absolutely.
Yeah, good. Or if you want to, you could report before that if you want to send out an email, but we'll talk about it at our next meeting.
Sure.
Okay, that sounds good.
Speaking of next meeting, what would the group like to do for a meeting schedule in the upcoming months? I think it's, I'm wondering if we can get maybe at least a couple of meetings on the books now. And if they need to be canceled, we can easily cancel them. But that way we can get them on folks' calendar and don't have to worry about trying to schedule something around everyone at the last minute. Thoughts?
Yeah. Should we come up with a day? What we have been doing, I think, is first Tuesdays, right?
Tuesdays for sure. Not necessarily always the first Tuesday, but yeah, Tuesdays for sure.
The Legal and Justice Committee meets on second Tuesdays, right?
Correct, on second Tuesday. So I've got a couple of dates here to suggest. Their third and fourth Tuesdays, actually, to try to schedule around Legal and Justice and some other groups. I started in June, but we can definitely start earlier than that if you'd like. June 22nd, which is a Tuesday.
I would hope we could start earlier than that.
Yeah, like hearing back from Andrew in February.
Okay, you want to start sooner than that?
I would think so.
I'd also like to see if we can do as much as possible to schedule in a way that Maya could join us, because I think she has a distinctive perspective to contribute.
Definitely, I will make sure Maya can attend. The feedback that she gave to me offline was just that she needs as much lead time notice as possible, which is kind of why I'm bringing this up today. On her behalf, and I'm sure maybe a couple others. So February Does February 23rd?
Let's see, that's a Tuesday, yes. Yeah, that works for me. I think the holiday weekend is the weekend before. Yes.
Yes, it is. And then April 20th. And then the other dates I have are June 22nd. August 24 and October 19. So these are all Tuesdays. They're not on days that Legal and Justice Committee meets. And I can email these dates to you guys right after this meeting. And if anyone has a conflict, you can let me know over the next week or so.
That would be a good thing.
Works for everyone, then I can go ahead and firm that up with Outlook invitations and such. How does that sound? So every other month for the next year in 2021?
Yeah,
I think that sounds good, and we can always call more meetings if we need to, if suddenly things are going along and we need more. I think that's good.
Absolutely. All right, great. Thank you, guys.
I will say, if and when I get vaccinated, I'll be taking some time off to be anywhere else besides my house. But yeah.
For you.
Yeah, I hope to be out of town, maybe between meetings, but I hope to be out of town for a while later this year. Yeah, we'll see. Okay, thank you for emailing those dates, Jill. I tried to keep up with you with my calendar, but an email will be more tangible. That's good. So, where do we go from here? Dave is going to talk to Damani and let us know potential contacts, and Carol and Stephen and I will try to reconstitute the list with the help of Jill. And then we can go ahead and contact those groups to make a plan to meet in I think a general discussion about the legal system, and here are the long-term issues that we're looking at, and here are the current issues that we're looking at, and we'd like to establish a dialogue. Do you all agree? So those tasks go initially to Dave and to Jill, but then, and Carol and I and Stephen, to the extent that we have information about the groups that we talked with. And then I'll circulate the final version of the near final version of the letter that we did that I'm just finishing up. And Carol and Stephen and I wrote a draft letter to start this process with. I'll circulate that to Dave Freeman as well. And then the next thing will be to put together our list and figure out how to contact people and when to set a meeting. Right?
Yes, I think so. And Jill, you helped support the citing and scheduling and logistics of a meeting last time. Can you do that again this time?
Well, if the meeting is going to take place anytime in the next 2 or 3 months, I would say it's going to have to be.
It's going to be a Zoom meeting. Yeah.
And yeah, Stephen, to answer your question, I can absolutely do that.
Thank you.
Maybe we should just call up everybody and say, let's meet at the ski area And we can meet in person and all stand 6 feet apart, and it'll be very refreshing to be in each other's presence. I'm kidding, of course. We'll observe all the regulations because we all want to stay healthy, and we have so far, so we'll keep it up. I think that finishes the business for our meeting. Does everybody agree? All right. Well, thank you all, and to be continued. Talk to you via email about scheduling, and then we'll talk from there. Thank you all.
Thank you, Your Honor.
Thanks.
Thank you.
Thanks all. Bye now.
Bye-bye.
Bye.